Okay, before we get started, I want to read this announcement about joining by Zoom. This meeting will be recorded. The Zoom application will notify you that this meeting is being recorded. Please press continue on the Zoom application to stay in the meeting. Use the raise your hand feature in Zoom when you would like to speak on an item, and also to lower your hand when you're finished speaking. Please unmute when called to speak and mute yourself when you're done speaking. If you're calling in by phone, identify yourself by name before speaking on an item. Press *9 on your phone to raise and lower your hand. Press *6 if you're participating by phone to unmute. So *6 to unmute. Okay, I would like to call this meeting to order. Can we take roll, please?
Chair, Councilmember Jane.
Here.
Committee member, Councilmember Shahal.
Present.
And committee member, Councilmember Park is on his way, just to be noted.
Okay, very good. We can move on to the consent calendar. This is approval of the December 2nd, 2024 Governance and Ethics Committee meeting minutes. Do we have any member of the public that would like to pull the item or comment on the item?
No members are online.
Not motion to approve the consent calendar.
And all second, all in favor? Aye. Opposed? Seeing none, passes 2-0. Okay, now we are moving on to public presentations. This is for any member of the public that would like to speak on an item that is not on the agenda. Any members of the public?
No members are online with their hands raised.
Okay, so now we can move on to general business. The first order of business is item number 2, presentation by outside consultant of the review of and recommendations regarding existing city's ethics policies and solicitation of committee input on appropriate next steps. This was deferred from the December 2nd, 2024 meeting. Staff presentation.
Sure. Thank you, Chair Jane and Member Javon Grogan, City Manager. I will introduce this item. First, I'll say that this item was worked on by a number of people in the City Manager's office, Nadine Nader, Maria Lay, and certainly supported by our City Attorney. We are here to provide you with a presentation from our outside consultant on the review of and recommendations regarding the city's existing ethics policies. And so by way of background, I know we've talked a lot about ethics policies and there's been a grand jury report. I just want to take a moment to set the stage for our conversation today, because this is essentially part 1 of a 2-part effort. So by way of memory or by way of background, you may remember that this very committee in June of 23 discussed the city's ethics program and referred the matter to the full city council. Then in July of 23, the full city council directed staff to have a special meeting where all council members would be trained on ethics, and that was a part of the AB 1234 training conducted by our city attorney, and we actually have a renewal of that training coming up shortly. The council also directed staff to explore hiring a consultant to review the city's ethics documents. And so the city in due course issued an RFP, and we selected LCW, Liebert Cassidy Whitmore, a legal firm that specializes in ethics as well as HR matters. And so Maureen Jacob is here and she will provide a presentation of their work as well as their recommendations, both on council policy as well as training. In addition, it is important to note that there were 2 additional findings that were in a recent grand jury report entitled Irreconcilable Differences. As a part of that grand jury report, the city council directed that the scope of work for the review of the ethics documents, which is what we're talking about today, be expanded to include one of the referrals regarding adopting a robust ethics training program. In addition, there was a recommendation to establish an independent ethics commission to oversee the behavior of council members to ensure that they model positive engagement with the public and ensure that public trust is upheld. That is part two. That work will be coming forward. We're here to talk about part one because that work frankly begun a lot sooner. So with that, I'll turn the presentation over to Maureen. She has her presentation as well as recommendations, and then staff is here to then support the committee with your deliberations and next steps. Maureen?
Thank you, Yvonne. Can everyone hear me okay? Great. Good morning. It's a pleasure to be here before the committee to speak on this topic. Again, my name is Maureen Jacob. I've worked with the city of Santa Clara on various matters over the year. We appreciate the opportunity to work with the city on updating its ethics policies. So as Jovan mentioned, the scope of my work at this stage was to review existing ethics policies that had been provided to me by the city. Those included the City Code of Ethics and Values, the behavioral standards for council members, the admonition and censure policy, ordinance at chapter 2.145. In addition to reviewing all of those policies, I'm also going to be presenting to you training recommendations today based on the ethics policies and the legal requirements that exist for ethics trainings. So I'm here this morning to discuss with this committee what the proposed changes are, and then ultimately, the plan is that I will be going back to City Council once this committee is ready to move forward. Jovan gave background as to why we are here, so I'm not going to cover that again. And I'm going to go ahead and launch into the updates that I'm proposing. So just for a little bit by way of my own background, I've been practicing with public sector agencies for 25 years now. I primarily focus on labor and employment matters. But given that we represent government agencies, we're also very familiar with policies tied to ethics and behavior of not just employees in the workplace, but elected officials, appointed officials as well. In my time practicing law, I've advised many agencies on these types of policies. And so I come today with the recommendations that I'm making as a practitioner who deals with these issues on a day-to-day basis, and as somebody who, has familiarity with the grand jury findings and whatnot. And so my goal was to update the policies in a way to reflect a commitment to ethical behavior on the part of council members. My hope for today is, should you have any questions, we can talk about that. If there are things that you were wanting to see in the policies that you don't see in the policies, we can talk about that as well. I want to encourage a discussion about the proposals. Okay, so the first policy that I looked at was the City Code of Ethics and Values. And what you have in your materials is not redlined, but instead is a replacement to the existing City Code of Ethics and Values that I'm proposing. Some of the components of what we have are similar to what your old policy was. I'm a firm believer that if you have something in an existing policy that is working, that we don't necessarily need to throw that out. What I would describe the additions that I have made to the Code of Ethics and Values as an enhancement of the policy and strengthening in particular the role of elected officials, behavior vis-a-vis city staff and community members, and we'll talk about that. So the first portion of the policy is the preamble, which sets forth that the residents of the city are entitled to responsible, fair, honest, and ethical city government. This policy focuses on the conduct of elected officials. In the preamble, it states that elected officials should conduct their official and private affairs so as not to give a reasonable basis for the impression that any such official can be improperly influenced in the performance of their public duties. The other value that is set forth in the preamble is that it's important that elected officials maintain an environment where all those involved in the governing process feel welcome to participate because they will be treated ethically and respectfully. The next section then covers the values of the elected officials, which drawing upon the existing policy include accountability for one's actions, fairness, meaning ensuring equity and due process where that is required, impartiality, diversity, embracing diversity, transparency, meaning that policies and procedures be open to public observation and scrutiny, and integrity, meaning the practice of being truthful, seeking truth, and adherence to the city's values. The policy then goes into the responsibilities of each elected official. And there's an expectation set forth that every elected official will uphold the code of ethics and values. And there is a list of 7 different principles that elected officials are expected to adhere to. I've also made a recommendation that each elected official sign off on this policy, which is a change from the current policy. It's essentially an affirmation that each elected official has read and understood the code of ethics and values, and they agree to adhere to and abide by the code. In addition to what we've covered so far, there's a component of the updated policy that deals directly with city council members' relations with city staff. And that's what the rest of the document goes through there. So there's in an introductory statement, a statement that elected officials must respect the council manager form of government that exists here at the city. It is the city manager who implements the council's vision, policies, and goals with the city staff. And the city manager is responsible for directing the day-to-day operations of the city. Elected officials, there's a statement that elected officials value the partnering and collaborating with the city manager and the city organization to achieve the community's vision. We go on from there to state that elected officials will follow certain guidelines when working with staff. And there are 8 different guidelines which really focus around treating staff professionally, which includes open and honest communication, practicing civility and decorum in all interactions with all city staff. Elected officials must be professional in all situations and circumstances, conducting themselves in a consistent, confident, competent, and productive manner. Following the council manager form of government, elected officials should direct any routine questions of city staff to the city manager, city attorney, department head, or designee, rather than working with staff one-on-one or directly. There is a guideline that states that the council understands that the city manager and the staff are responsible for implementing the council's actions. Let's see. There's a specific guideline I want to highlight, number 6, that elected officials should not direct the city manager or staff to initiate any actions without the approval of the council. And it is the city manager's responsibility to advise on resources available and required for a particular course of action as it relates to council direction. Let's see. And then lastly, falling in the theme of, the city council should be utilizing its city manager to be communicating with the staff. To that end, elected officials should direct any concerns related to the behavior or work of a city employee to the city manager. And then the city manager and staff can then address personnel issues directly. Okay.
We take questions on this rather than wait till
Yes.
the end.
Sure.
Okay. Because I think this is very important. It's better to break it out as we just discussed. So are there any questions? Member Chahal.
Thank you. Thank you, Maureen, for the presentation. So I have a question regarding item number 3, dealing with the staff, basically. We do have a notification from city manager note on that, like how we contact the different staff members. And department heads are basically not officially, but we can still contact them as long as we keep the city manager in the loop for that. So this document is basically saying you can contact the department heads, which is not the current practice in general, only in case of when we need something urgent, when city manager is not there, then we only contact. So I want to clarify that contradiction between the current setup and this one. So maybe between you and the city manager.
Sure. And is the, sorry, Jovan, I was just going to ask, just to clarify, is the suggestion then, and I'm here to get direction from the committee, is the suggestion that we don't want this to include department head, that we in fact just want council members to go directly to the city manager or the city attorney?
Sure.
I'll let the city manager respond.
Yeah, let me take this. I think it's appropriate for the city's council's ethical statements to say, to reference the council manager form of government and to have your interaction with staff through the city manager, right? Some city manager, right, and that's the way council manager form of government, right? Council does not provide direction to staff, only to their appointees, in this case, the city manager and the city attorney. However, one of the things I've done that council knows is I've issued a communications memo that prescribes how council should interact with the organization. That provides a number of things. One, it provides, if you have a constituent question, if you have a question, where those should be routed to be most efficient. Also, I prescribed out a process where council members can contact department heads, generally commonly referred to as a 10-minute rule. If there's a quick question for a department head, feel free to ask the department head that question. Make sure you copy the city manager so that I know that question is being asked, but I don't want to be a cog in the wheel, right? Not all city managers that operate in a council form of government do that, right? And one of the things I've said is that should it ever become a problem where council members are utilizing that to ask elongated questions, right? Taking up more time or seeming to direct staff, I would pull back on that. And so I think that that is appropriate and the outline of that is appropriate from a communication that comes from whoever the city manager is to the council. At the same time, I do think the council's policies document should fully reflect the council manager form of government. And maybe we can add something in there sort of as designated or delegated by the city manager. That way it's clear in the policy document that if in fact council members contact beyond the city manager, it's been delegated by that city manager.
Thank you. Yeah, I just want that clarification because we can include the city manager memo or city manager direction for that. We don't want it to be a confusing that, oh, one document says point blank, we can contact the department heads. Other one says only in case of so and so, so and so. So that clarification would help basically.
Will do.
Thank you. My other question is on item number 6, where we say prepare any report without approval of the council. So I just want a clarification on that because we hold one-on-one meetings with the city manager or city attorney, and at times we ask some data, right? It may not pertain to full-fledged report, but anything we request can be part of the report. So I want a clarification on that. Like we don't want even a small report, small information we are requesting from the city manager. It should not go back to the council. And this is not, I'm not trying to pick any one right now in this. I'm just trying to clarify the document so that it should be universally applicable in future generations, basically. So what I think is prepare any report without the approval of the council. So I think we need more clarity on that. Like if I am having a meeting with city manager and I need some information which may demand some data, basically some report. So how do I have to route it through the full council, or do I have some, just like city manager said, he will issue a memo. That's how, if it's less than 10 minutes of time, staff time, you can contact the department head, basically. So I want some clarification on that it should not be taken, any report for city manager has to route it through the city council first, not directly by the council member or the mayor or vice mayor.
Great question. So let me talk a little bit about what I was thinking there, and then perhaps, I can refine this language a bit to make it more clear. What I was trying to achieve in this number 6 was a guideline that city council members are agreeing not to take any action that has not been approved by the council. So in this context, where I'm talking about preparing any report, it is, report with a big R, a report that purports to be one issued by the council, that no individual member would take that upon themselves unless there is direction from the council to do so. So I don't know if there is, and it's helpful for me as I'm updating these policies, if there is a different practice, or, if you feel like this doesn't make sense for us, Maureen, we're not issuing reports from the council, let's talk about it. But I feel like Councilmember Chahal, you might be using the word report in a different context, like information sharing is what I'm hearing you talk about. And that's not what this is intended to address. So if it feels like that's what it does, I will revise it to try and eliminate that confusion.
Yeah, might I suggest just adding formal report or something to that?
Okay, yeah.
Council Member Park.
I realize that this is directed towards mayor and council, but there are other elected officials that also need to adhere by these standards. And I feel that when I see this policy applies only to the mayor and city council members for improper conduct, I feel like all elected officials should be included in this. Oftentimes we think that the city council are the major components of the city. And I think that, no, I think that every elected official is important in that regard. It's also clear that council is told what's right, what's not right often. But staff, I don't know how much staff is trained on what is right and what's not right. Oftentimes staff is in an uncomfortable position because, well, it's not clear to them. Oftentimes I have seen people do things that, well, I think I need to do this. Well, you don't have to do that. And even in the governance and ethics committee meetings, I've seen people ascribe capabilities and authority to members of city council or mayor that aren't actually powers of the city council. And I think that everyone, like both sides, all of the sides actually need to understand that if somebody asks you to do this, then this is what your options are. And on the other side, these are the options of what you can and you cannot do. But without both sides doing this, people can inadvertently can actually make a request, and the expected outcome will not happen because of a lack of understanding on one or both sides.
Do you have more questions, or would you like the manager to respond?
We can respond, but I mean, we have a lot more to go through, so I don't want to spend too much time right here.
Okay, if you want to respond to that, and then I have some questions.
Sure. And I think that there were 3 items that I wanted to respond to, but I think going back to committee member Jahal's comment about recommendation 6, I think it's important to point out that what recommendation 6 gets at is that elected officials should not direct the city manager or city staff. Key point, when we all know about that, key point is or prepare a report without the approval of the city council. And then I heard Chair Jane say a formal report. I do think it's worth talking about the presentations that happen at our city council meeting from elected officials, right? Someone could call that a report, right? It is not common, I would say, in my professional experience, that council members prepare their own PowerPoints and present things at a council meeting, right? That does happen here sometimes, right? And so I do think that in looking at this recommendation, it's worth talking about that. And does the city council choose to accept that? So that would change our current practice, or does the city council choose to add clarification here such that it will still allow for council members to conduct their own research, prepare their own PowerPoints, and at a notice meeting, present their own information to their colleagues. Again, this is the first time that I've seen that. I would say that that is fairly atypical from my professional experience, and I know some of our other professional staff, but that does happen here. I just wanted to call that out as something that's embedded within item 6 that I think we should talk about. With regard to committee members Park's comment about expanding this to all elected officials, I think that is something we can take back. Certainly when this effort begun, it was looking at city council only. How it would apply to our other 2 elected officials, one of them being the city clerk here, I think could be almost fairly analogous to how it applies to the city council. I think how something like this applies to the police chief, that has a distinction of being an elected official and more of a regular employee as well, that makes operational decisions, I think will require us to look into that a little bit more clear.
May I ask, or just add one point to that, with the examples of the city clerk and your police chief, who I would describe as, a hybrid position, although, they might be elected, they fall under the city's employment and personnel policies. And so one question I would have that I'm happy to work with city staff when we go back to look at this is, are there any existing policies that would address their behavior and how they are conducting themselves that we can fall back on so that we are limiting this policy to the conduct of elected city council members? Just a question, not.
Okay, Member Chahal.
City manager, I think on number 6, I think this is the one you were talking about example, and a council member preparing a report and presenting at the council meeting. That's what you're talking about, right? I think we don't want to take that privilege out because council members can speak when they're having discussion. And if there is a adequate way to present something in form of a PowerPoint, that privilege should not be taken from the council members or from the mayor or anybody, basically. I don't want, committee can decide on that, but I don't want to take out that privilege because speaking on it and just presenting on something that almost the same thing. But if we want to make sure it's more transparent and understood by the public in form of 4 or 5 slides, I would not like that privilege should be taken out from the council members. So that's my first point. And this one pertains to basically only reports directed by, let's say I ask you for something. I think that's what this point number 6 says. This is only report to be prepared by city manager or basically staff, but through city manager only. So that was my difference. I think
Okay, so of course, this whole committee works in the gray areas. So, you know, when I first got elected, it was 2000. We were in the middle of COVID, and I had, 2020. I had the issue was that we could never meet with any of the employees. Everything was through Zoom. And what happened was the city manager controlled everything. I could never talk to any department heads to understand how they were being treated by the city manager, how their experience was working in the city. And I'm trying to understand, you know, when I do meet with department heads, I get a sense of how they're feeling about the city, you know, at some point, we're supposed to do reviews of the city manager. And it's impossible to do a review without talking to the people that work for the city manager. So I like the ability to be able to talk to some of the department heads, and I like the 10-minute rule. I think in our charter, we have the councilmanic interference in the charter, which I would like to get rid of, and put in a policy like this. In terms of asking the city manager to initiate any action, you know, we have one-on-one discussions, and I'll say, well, I would really like for the city council members to get tours of Santa Clara University, right? And what I would say is, I should be able to ask that, but the city manager should be perfectly willing to refuse that and tell me to go do a 030 and make the whole council basically make him take action on something. Because there's a lot of things that come up in our one-on-ones, things that I would like, you know, to see move forward in the city, that I could, and I've done many, many 030s. It just seems like a very cumbersome process for me to do 030 to ask to repave Hillmar Street or something like that. So, and in terms of presentations by council members, I've done a number of those. I think Member Chahal has done those. And on VTA, we have colleague letters. So there are VTA board members that issue colleague letters that are in the packet. They're basically presentations. So it's not totally unique to Santa Clara. So those are kind of my comments on having the impromptu meetings or having meetings with department heads. I know that in the past, there was a council member who would go and sit in department heads' offices for hours. And, you know, to me, that was councilmanic interference, but nobody seemed to mind that issue. And I like the 10-minute rule. In terms of this first part of this, which is the code of ethics, these categories, accountability, fairness, impartiality are different than in our previous code of ethics, which had like ethics and collaboration and other things in there. So I know when we get elected, Nora, can you confirm this? When we get elected, we sign a code of ethics, right? When we get elected as part of our,
So you signed the code of ethics that pursuant to the election code, which
Right.
is the form that's included in your packet when papers are issued.
right. And then assuming office, there's nothing that we sign? I thought there was, no, okay. So this is the first time that once you're elected, you would sign an ethics code? Is that correct? This is
So
new?
once you're elected, you file, you're assuming, Form 700.
Yeah.
But as far as signing another ethics code, you don't.
Okay. I got confused.
It's a
between
new recommendation.
The new recommendation, okay. All right. I think that's all I had. Thank you. Yes, city manager.
If I can, a couple things. There was a comment about talking to department heads in order to assess the work of the city manager, right? I happen to be the city manager, so it's a little weird for me to make this comment, but in general, what I would advise is that the city manager's review process should be dictated by the city manager's employment contract and the city council's a review process as supported by HR and designated through the closed session. And so the point of a council member having conversations with department heads, a review of a personnel issue really shouldn't happen in that context.
I wasn't
Totally.
suggesting that. I was saying just to get a feel of how happy they are working here and, things like that.
Totally understand. It just,
Yeah.
the review point I wanted to note.
Jovan, may I just add a point to that? I want to reiterate Jovan's point on that. In my experience, and I work with cities and counties throughout the state, there is a specific process for reviewing the performance of someone like a city manager. And, the strong advice would be that we follow that rather than informally speaking with, department heads or other staff to try and gauge that. And again, not suggesting, Chair, that you were saying that that's what should happen, but I just wanted to reiterate Jovan's point.
I think and the other key thing about number 6 is that it talks about directing the city manager or city attorney. And I think the chair correctly said that oftentimes there are conversations that are a request and the city manager or the city attorney have the ability to say, not going to accept that request. In many ways, it's a bright line because while a council member may say something as a request, right? If it's something that the city manager or the city attorney was not already planning on doing during their normal course of work, it would be inappropriate for me, for example, to undertake actions that council members request during our one-on-ones that's not authorized by the full city council because the city council operates as a body, right? So when city managers across the country have one-on-ones with their elected board members, they're typically information sessions, right? And the elected asking for information, the city manager providing an update on current events. But typically anything that revolves a request from an elected official for the organization or the city manager to direct staff to do something new or change policy, that really has to be governed by the full city council, right? Oftentimes, in my prior experience, an elected official may say, I really would like us to have X program to deal with this portion of the population, right? If a city manager took that as direction and just went out and did that, I've often seen that's when city managers get themselves in trouble because they're viewed as doing one-off projects for individual elected officials. Oh, this council member said they really would like us to do this, and so they did it, and they did it, right? And so as a city manager, you really have to take a step back and understand that's your position. You know, you really have to work with your colleagues and have the full city council direct that. Typically, anything large to go to the annual priority setting process, or we have a 030 process that council members can request. I'm in the moment trying to think of a situation where it would be more okay for a manager to take an action. And I can only at this moment think of providing an example where a council member makes us a suggestion and the city manager hears that suggestion and it's something already in their operational scope of duties. It's an existing city program and the city manager can hear that information from one or more council members, but they have to make their own individual professional assessment on, you know what, I think the organization should do X, right? Because then they've just heard their opinion of their elected officials and they've made their own independent decision. That said, also in my professional experience, I've seen where city managers have been called to task for that very same point and been accused of Brown Act violation because they asked this council member and that council member, or not even asking, more than a majority of the council said, I think, you know, I really would like us to do X or we should do X. And then the city manager makes that decision. It's a Brown Act violation and someone could make a claim and potentially be successful saying that you had a serial meeting and you did not as a professional make your own independent assessment. You essentially counted votes through your one-on-ones. And so it's a very almost challenging area to administer, which is why I think policies should be very clear saying council members should not direct professional staff to undertake any action or prepare any reports.
And as an individual, I've also seen situations over the years where individual city council members will go to a city manager and then the rest of the council is really upset that, you know, they will claim that that city council member stepped outside of any authority that had been granted by the council as a whole to take any action on a particular issue. So that's, you know, another, in addition to what Jovan described, I've also seen that happen before.
Member Chahal, I think you have.
Can I have a clarification, a comment, or maybe that have a response to that? Let's take an example. I just noted down two. Let's say I go to city manager and ask him, hey, due to one reason or the other, how many permits have we issued in last 1 year, which are less than 500 square feet? Or to the city attorney, in the last 1 year, how many cases we dealt with where we spent more than 100K? So, and that report is, if I'm not saying just give it to me, it can be go to all the council, but that's not a policy decision, which is, I'm not talking about any implementation of a new policy or so I'm hoping that is not covered under this parameter. Basically, it should be like such type of data which we need, and it can be supplied to whole of a council. Not even if I ask it, it can. I'm trying to avoid that such things should not be included in it, and this is why I'm asking my current city manager will give it to me or not give it to me, not with the particular gentleman or gentlewoman right now, but just to clarify this thing for future so that it doesn't have any issues related to operations or how the process works basically.
Chair Jane, Member Chahal, if I might, appreciate that question and it's a good one. And the manager and I are aligned, you know, on this. A lot of those types of requests come down to the amount of work that would be involved. And if it's something that we can readily obtain, it's the kind of thing we think is appropriate for all of you to have, that can and will be something that we would do without formal direction from the city council. When it crosses a certain threshold and starts to consume resources that are substantial enough that might get in the way, you know, and with other priorities or delay our ability to do other work, then it's something, and we've had conversations with each of you, right, that we might say, you know what, I can't just do that on my own. Please submit a 030, or let's talk about how I might get council authorization, you know, for that, because it's substantial enough consumption of city resources that it's appropriate for me, city manager, or whomever you're making that inquiry, with to do that.
And just really quickly, I'll agree to that, but add another example where it's not just the time, but it could be the number of requests, right? For example, the 10-minute rule, right? Well, if one council member asks 30 10-minute questions, right? Then the city manager would typically go and say, hey, it's becoming, it's impacting operations and diverting staff from doing their normal course of work. I'm going to ask you to pull back on the number of your requests and or submit a 030 to have the full council provide direction.
And if I might say, I don't think this provision, although certainly the section 6, right, we're talking about, it certainly could warrant some modification. I don't think as drafted, it compromises any of those types of, communications and our ability to respond in that way. It really is, to city manager's earlier point, difference between direct and request. Requests are something that we need to manage as part of our, responsibility and relationships to each of you individually and to all of you as a group, that we need to triage, and communicate clearly with you about what we can do and what we might need further direction on. But it really is from an ethical, drawing the line, consistent with council, city manager form of government. The importance of that, the word direct, I think is really what the emphasis of that section is.
Okay. I just want a clarification that it should not be construed the other way around, that we can't even ask any information. Yeah, right, got it. Thank you. Thanks.
I think, I personally would like us to expand this section to more formalize the role of the 030 and the ability for the city manager to push back and say, you need to do a 030, or this is taking up too much of my time. I would like to see that more formalized because, again, I agree with Member Chahal that if you ask questions that require a survey of all of the properties, that could be, more staff time.
And if I might, Chair, I think that's appropriate. I think, and with the other example, with respect to section 3, all of this needs to be dovetailed, with existing city policies, in order that, and this is something that drives lawyers crazy, so we're all very supportive of this concept, that everything hangs together and makes sense. And you're not looking at one document that says one thing and looking at another one that says another thing. And so what I heard outside counsel appropriately suggesting to you with respect to section 3, and I think it could be appropriate here in section 6, is that some language that clarifies and connects this with existing city policies and says, this does not mean you can't request the city manager, but the city manager or city attorney or whoever the inquiry man has the ability to direct you to, if substantial resources are involved, to either filing a 030 or some other priority setting session or some other mechanism. So I think we can certainly work with the outside counsel to come up with appropriate language that addresses both those things.
I agree. And I would just say we shouldn't name the city policy by name because that will change over time, where the ethics policies should stand the test of time.
Except these policies always change too. Anyway, we can move on to the next, unless we have, I guess I'll ask for public comment. Okay, we'll go back to the PowerPoint.
So, we've been talking about the city code of ethics and values that focuses on the conduct of individual council members. The next policy that we are looking at is the admonition and censure policy, which is designed to give the council the ability to take action against its own members for violations of their code of ethics and values. And so in the admonition, censure, and policy, I ended up updating the policy to give it a little more structure was my goal in terms of setting forth, the differences between what an admonition is and what a censure is, and then setting forth the procedure or procedures associated with admonishing one of your members or censuring one of your members. So with that in mind, in the proposed policy, the purpose sets forth that the policy applies to the mayor and the city council members for their improper conduct that could result in admonition or censure. There's also a policy statement in that purpose section that states that city council members shall abide by all laws and shall abide by city policies, including the Code of Ethics and Values, which we just took a look at. Any violations, there's a recognition that any violation of state or federal law, city policies, or the Code of Ethics or Values undermines the effectiveness of the city council. And so the remedy that's available to the city council is to admonish or censure any council member for violation of this policy. Now, sometimes conduct is criminal in nature or may be criminal in nature. Sometimes alleged conduct could violate the FPCC. And so there's a component where I'm seeking direction from this group today. So if you are following along in the policy, I'm under the purpose section. The third full paragraph states, for violations of city policy, council may take action to admonish or censure the council member in accordance with this policy. And here's my first question to this group. So it says, for criminal conduct, the council may or shall, and the direction I'm seeking from this group is, do you want that to be may or shall? And we can have a discussion about that. For criminal conduct, the council may or shall refer the matter to the office of the district attorney for handling. And part of what I'm intending to do there is to take any type of criminal conduct really outside of the council's hands. We want that before the office of the district attorney. And the reason for that is because the charge of the district attorney is to investigate potential crimes. You are focused on violations, not of criminal laws, but civil laws, city policies, not criminal matters, which should be handled by law enforcement. And then with respect to FPCC violations, same question there. Do you want that to say may? Do you want it to say shall? Do you want to leave it may and shall? So that's a question that I had for this group. And I don't know if you want to discuss that now or.
Yeah. As you begin to think about discussing it, I think it's also worth noting that this may change with the establishment of an independent ethics commission. And so that work, as we talked about, is still phase 2, still needs to occur. And then the council, the committee, and then the council will have to make a decision. But you can very well make a decision based on policies now. And then if a independent ethics commission is established, you can delegate that power to the commission.
Yes, and then when we do come back to talk about that phase 2, if there are recommendations to modify any of these based on the establishment of any ethics commission, I will bring those forward.
And I think inherent in here, also worth noting that the DA may choose or council may choose to refer, and the DA may choose not to investigate something. That doesn't mean that it's not a violation of city policy that the council could still take up as a admonishment or a censure.
Is there more or?
How about, yeah, why don't I, and this may help, with your thinking on the may versus shall up there. But let me go ahead and talk about the difference between the admonition and censure, and then we can go back to that. So an admonition is defined under the definition section there. It is currently set up so that any member of the city council may admonish any council member during a meeting. So an admonition is defined as a formal expression of disapproval that serves as a warning. So an admonition is a warning to correct inappropriate behavior that is short of actually imposing any discipline. And so any council member can do that. Then we go to the censure, which is a more formal action that's being taken against a member of the council. And so because it is a punitive action, my recommendation is that it should be, a censure should represent the collective judgment or agreement of the city council. So there's a procedure, if you move down in the policy, there's a procedure that I've proposed for the censure process. And again, to Jovan's point, depending on where we go with the phase 2, if there's an independent ethics committee, commission that we end up recommending be established, that could impact this. But within your current structure, the recommendation that I came up with is set forth in the procedure here. The one highlighted section that I had a question for this group was what percentage vote of the city council would be required to censure a member. And I've set forth, either a majority or a 2/3 vote. I've seen it go either way. So that's an item for discussion for this group. Happy to answer any questions, or if you want me to go through the procedure step by step, I'm happy to do that as we sit here, whatever is helpful for the group.
Member Chahal, did you have a question?
Yes.
Okay.
So I'll go back to the last part, council vote, basically 2/3. Let's say member X is being censured, right? He or she will be participating in this vote.
They would not be participating if they are the subject of the potential censure.
Okay, so basically we are left with 6 votes then. And that's equivalent to the majority of the council. So I don't think there's any confusion on that, because 2/3 of the 6 will be 4, and 4 votes are the majority of the council. So that doesn't mean, if the member X who is being censured is part of the voting block, then it will make a difference, basically. So I wanted to clarify that. Yeah, that's the only clarification.
Yeah, I wonder if you could make a policy that would do 2/3 of the members participating in the censure action. Because, for example, you could only have 6, but maybe it's a censure about the actions of 2 people, right? And so you would only have 5, and so it's 2/3 of the 5. I mean, I think.
I think that's a good suggestion.
Okay, I see here that, under the actions for censure, you have, removal of committee assignments and such. In the past, censures have been weaponized, you might say, and people have been censured, but there's been no consequences. There's been no removal of committee assignments or visits to conferences. There's been basically no suspension of any privileges. And I'm wondering, how would we decide on what privileges would be removed? if the censure were to pass? Would that be another a motion of the council to remove the privileges? It just seems to me that we've had a number of members of the public that have filed 030s. I think we clamped down a little bit on the 030s to initiate censures of council members. But in my experience, at one point, it was heavily weaponized due to politics. And I wanted to somehow prevent that. And I don't see any real method to prevent that in this.
Don't see a real method. I want to make sure I'm understanding the concern to prevent what specifically.
Issuing a censure of somebody, it could be something very minor, but if the council is very politicized, then, it doesn't even have to be that you violated an FPPC policy or you violated our code of ethics. It was just like, in one case, it was that council members didn't vote to appoint somebody to the council, and to me, that seemed like it was well within their rights to do that, and yet they were censured, so.
So the policy as written in the purpose section speaks to for violations of city policy, the council may take action to admonish or censure a city council member. And so what I was trying to achieve there was to make it clear that there needs to be a finding of a violation of city policy to be able to admonish or censure. So I'll stop there, but it's for this group to decide from a policy standpoint if you need more teeth to that, if it needs to be better stated or differently stated. I understand the concern, Chair, about the politicization of, these tools of admonishments and censures. How we would write that into the policy itself, we need to be careful about. We don't want to inadvertently run into any issues of violating the First Amendment rights of individual council members. So it's not possible to write every scenario into a policy. But, I take your point is well taken. So if there's, additional points or discussion about that, happy to listen to that.
Yeah, I think like on planning commission, when you have like quasi judicial decisions, you have to come up with findings. So maybe we could formalize a findings mechanism.
So that is, if you go into the procedure, I have set up this ad hoc ethics commission that is essentially charged with investigating and making findings. So if you go to the initiation and review of censure under procedure of censure, that very first section, it says any member of the city council, a staff member, or a member of the public may raise concerns about a council member's conduct that may warrant censure. The concerns must be submitted in writing to the ad hoc ethics commission, detailing the specific behavior or actions in question. After findings are made by that ad hoc ethics commission, then the matter comes back to city council for action. And so a censure under this policy would not, if it warrants looking into, would not just be initiated, without some sort of inquiry by the ad hoc ethics commission.
So we don't currently have one.
Correct. This is a
So-
new recommendation.
So if we don't establish one, then what would happen?
so if you don't establish one, then I would, if the decision is we don't want that, you know, I have a point and then a comment. One point would be based on the grand jury findings. This is why it was the grand jury reports that inspired me to set something up like this, because I think that some of the findings in those reports wanted to see something like this built in. Point number one. If we don't have something like this built in, I would need to think about a new procedure for a censure process, which I have not done. So if it's the request of this group, Maureen, we want to see an alternative to this, I'm happy to prepare that, but I don't have that for you today.
Okay, it's not clear. I mean, very few cities have these ethics commissions. It's not clear, you know, what kind of budget, how it would operate, all of that. So that's still up in the air. I mean, that's part two.
Yes.
So I think maybe some thought about what would happen if we didn't.
Yes. I can definitely do some thinking and come back with alternatives.
Member Chahal.
So I want to make a comment on purpose part of it, like we did talk about FPPC complaints, right? So I would suggest like even that has been weaponized in the past. So anything which is pending at FPPC for any member, that should not be part and parcel of the censure or admonition. Because anybody can complain something which, and FPPC take long time to find the facts or the investigation. Until that time, the people can be, oh, censure him or admonish him for he did this, he did that, or she did that. So I want to make clear that no admonition or censure should be taken up if the FEPC has a pending case.
So the one question I would have back to that point is, what if we're dealing with behavior that would also violate city policy? Something could be a violation of the penal code, you know, criminal law. It could be a potential violation of FPCC rules, but then it could also violate city policy.
Agreed. Behavior is not covered by FPPC anyway, right? So that covers under our ethics policy, will be covered under our ethics policy. I'm okay with that. But I'm talking about something which is alleged under FPPC complaint.
Yeah.
It is not related to behavior, it's related to some process or something happened in the past.
Yeah.
So I'm not talking that we should give a blanket excuse for a behavior. Even if it pertains to FPPC complaint and there's a side effect of that is a behavior, you can take up the behavior part of it, but you should not take up the FPPC investigative part of it.
Understood. My intention in this paragraph was to, I think, do that. My intention here, this paragraph starts, for violations of city policy, you can admonish or censure. And then it goes on and says, but for criminal conduct, we're referring that to the DA's office. And for FPCC violations, we're referring that to the FPCC for handling. So I was trying to get those matters out of the hands of the city council. But with that said, there will be times where criminal or FPCC violations also violate city policy, which I then think puts that back into your purview and gives you the authority to either admonish or censure.
So if I might add, Chair, and this may warrant it if we go down this path, another paragraph, right, to make that distinction. Completely agree with our outside counsel regarding that. There could be overlap, however, between matters that are referred to the FPPC and the kinds of determinations that need to be made by the FPPC as to whether or not that particular constitutes a violation of the CPRA. And the factual determination that would be necessary in order to determine whether or not that was a violation of city policy. Where there is that actually commonality of the factual determination necessary, I would put that again back in the FPPC, category, as opposed to something that we would be independently investigating, along with the FPPC. So there is some nuance and subtlety to the point that I think another paragraph can help get at. I completely agree that matters that are referred are matters that should be left to that process and the outcomes and determinations of that process. What, if anything, that might be a underlying kind of behavior or conduct that might still be a live matter of city council jurisdiction and business, I think warrants some additional thought and maybe another paragraph in order to create that distinction. And my outside counsel's nodding, so I think
Yes.
I'm onto something.
Nodding and taking
Yeah.
notes, yes.
The other thing that I might add that's maybe part of the challenge of the initial question of the may shall is what do we mean by that, right? When we say that, because you might get any number of different, to member Jane's point about weaponization, allegations of things about people behaving in a certain way that, if true, could be a violation of state law or conflict of interest laws. At what point does the city council, what level of investigation, what level of consideration do you now take that matter up and make a formal referral to the DA or to the FPPC? Because that's different than merely steering someone, to the FPPC or the DA. If every time anybody accuses anybody of anything, I don't think we want this policy to say, if it says shall, that you now have an affirmative obligation to make a formal referral of the city council to the DA, because that gives it some weight, which it might deserve, but it might not deserve. And without some level of investigation, which I think this is not intending for you to get into, you wouldn't be able to distinguish that. So I think as part of that kind of may shall, analysis, one of the things to consider, particularly if you go shall, and this may be a reason not to go shall, is what level of screening or triage, would you be expected to make? And of course, then therefore potentially staff being, expected to engage in on your behalf to any, who knows how well supported, who knows how politically motivated, who knows what, right? Create a distraction of something that really might not be a there. So just introducing that to the may shall conversation, but because I selfishly have an interest in not wanting every particular thing, that gets brought up to be something that you now need to formally take up and potentially make a formal recommendation.
So with that said, I would say let's use may.
Yeah, I pretty much agree that when you say criminal conduct, is that just alleged? And then you have to refer it, or is it, that there actually somebody else started an investigation? It's difficult to decide where that triage kind of lands. Member Park, you have a?
So many things, like I can't believe they put other things on the agenda in addition to this item, because this is a big item. So I think that if something is criminal, then it's kind of like putting the cart before the horse if you also do a censure action. I kind of feel that if there is an FPPC violation, if something's being taken up by FPPC, if something's being taken up by criminal investigation, then that's the investigation, that's the action that's being taken. To put a censure on top of that is already to deem that there is a problem, even before it's come back from the FPPC or the people doing the investigation. So I think that with the criminal with an FPPC, with a process violation outside of the jurisdiction of council, it doesn't make a lot of sense to do that. I see that the city manager has that.
Yeah, no, and through the chair, thank you, Committee Member Park, for raising that. I was actually going to make a comment to that point because respectfully, I want to suggest that situations are different and these policies should be broad to allow you to operate based on what is before you. Committee Member Park, I actually totally agree with you. In general, if it's a FPPC and a criminal matter, the council should likely defer to those bodies before taking a admonishment or censure. I would proffer to you an example though, and I think we have some recent examples of this. Let's say that a council member is accused of something pretty egregious, even let's call it child pornography. Let's presume that the criminal process is taking its course and its time. Let's presume that there are public calls for someone to resign. The council may very well want to take a censure of that council member because maybe there's enough information out there in the public domain or that person has said things where while the criminal process is still ongoing, the council may say, you know what, we may want to make a finding that we feel that this person violated city policy and we feel that they should not represent the city at city committees. And so we want to censure them and take away that ability. They are choosing not to resign. They cannot be forced to resign until the criminal process takes its course. But the council may want to and may be facing significant public pressure to actually take an action before the criminal process concludes. And so I just wanted to proffer that as an example and as a reason why I think these policies are typically written to be broad, because the case specifics are really going to dictate what action you take. And I think, of course, inherently, you know, there's really not the ability to fully remove the politics out of it because you have to question why a elected official is making that decision. Are they saying they believe it because they truly do that, or if it's political? And, you know, oftentimes it's so subjective that we really can't make that determination.
So I hear your point about but again, when people say, oh, but there's enough information in the public to make a determination, I think that's a very slippery slope. The second thing I want to say is I don't want, let's say somebody has had an FPPC violation or the FPPC has taken action against them. I mean, this happens, people think, oh, that is a really big thing. It happens often where people, especially new, and if you go to the orientations and you talk and you hear what happens, people misfile things or have to make corrections all the time. This is not a big thing, but to use something that the FPC or another body has already prescribed a punitive or restorative action, I don't know that those should be considered reasons for an admonition or a censure either. I mean, it feels like the correction has already taken place. And at that point, you're just piling on top of that. And it's kind of like double jeopardy. I do have concerns that the policies that I see are written kind of like what we call in engineering blue sky or green grass policies, which is they say, well, if everyone's reasonable, everything's going well and things are understood, then these policies are going to work. But it doesn't really reflect the realities of the practical realities of the way councils are. I mean, I've attended, I've witnessed several actions in other cities, some nearby, and I've seen that some of the actions they put in place. Chair Jane has suggested that we could remove council committee assignments and things like that. And this council has undergone admonition and censure, and there were no options brought up. I think that having options would be a good thing. But again, I don't think it should be an easy thing for people to simply say, I would like to admonish. But when I read the admonition, I don't know if there's a vote, doesn't talk about that. It just seems like during during one of these sections, I can just say, I admonish, Councilmember Smith for this, for attending this, a parade in the wrong attire. And I don't understand what, what that would do. It just seems very fluffy to me. So many things. Right. And again, I feel like if we're doing censure, there has to be a pretty big bar for censure, and we need to make very clear what the specifics are. Because when we say 2/3, 2/3 of what? I mean, we just brought up here, is it the 2/3 of the council members that are not being censured? What if 2 of them are being censured or more? Do they have to recuse from all of them, or could I be part of a vote, or could one of them be part of a vote that says, I would like, 2 of us are being censured, I vote against the censure for this person, right? I mean, there are a lot of situations in there that have actually happened that we're really not thinking about, and that's my concern. My concern is somebody happens, and mathematically, I know it's very difficult for this to pass or this to not pass with these numbers. So I can just say, well, this is what I'd like it to be. And the answer in all cases should be, no, this is what the policy says, right? The policy very specifically takes this into account. And right now, there are only 7 council members. And even if we had to do situations that go to all of them, every single one, that's not really a lot of options. Councils in Santa Clara tend to be split along lines to explicitly state that some people can vote, or some that you can almost guess what the outcomes will be. At the same time, I have a little bit of concern when you tell me that many of the things that you brought up were brought up because of the civil grand jury report. Because, I mean, what is the civil grand jury? I used to think the civil grand jury was this pretty big thing because the name seems pretty formal. But then again, so does, High Chief Magistrate of a king, and I'm just a friend. And my concern is, who are the people that are on these ad hoc committees? And the short answer is they're volunteers. And the people who volunteer for these committees often have the time, they have the money, they don't have to work, they have the will, political or otherwise, to volunteer for these committees. And I think the same thing, people tell me, don't say this so often, but it's absolutely true. What do elected officials know about anything on governing? And even more so, volunteers for an ad hoc committee, especially when the outcomes of those committees are very political or can be. For that reason, I 100% want to look into alternatives or ad hoc committee for an ethics committee, because, I mean, we see it even with commissions. We get a lot of people. There are certain types of people that apply, and we need something that is actually independent. But to have the appearance of independence by saying, well, we accepted volunteers and there was no vetting process, there was no, it's not like a traditional jury. That's why I think civil grand jury is a misnomer. It's not a jury of peers. It's just a group of people put together for a purpose. And nobody says, well, this person seems to be biased in some sort, so we can't accept this. That doesn't happen. I mean, if there are 20 spots and 20 people apply, every single one of them is accepted. And I don't think people understand that. I think that it's hard for me to sit here and hear that, well, the civil grand jury led me to think these things. I think that the civil grand jury is nice. That's good input. It's what I tell people about engineering, which is I'm very happy to hear what the man on the street thinks about AI, but the concerns about AI should not just come from the man on the street. The man on the street informs us in how we tell, how we market, how we talk about those things, but the people who understand the dangers of the technologies are the ones that should be making the policies. And in this case, I don't know that the civil grand jury has any weight to actually tell us what the processes are. I know that we think that they're supposed to, but anyone who's read the reports can see that, we don't come up with inaccuracies. We don't actually talk about the inaccuracies enough. We talk about the findings, and the findings were made without due process. And I want everyone to know that. So I would like to see alternative processes. I would like to see something other than, if it's going to be independent, I don't want it to be individuals from the city, individuals who vote, to be part of that. I would like people who don't have a vote, who aren't affiliated. This is, I think that's a tremendous problem with this entire process. So again, I would like to see a little bit more detail. I'd like it to be crisp when it comes to who can vote, what are the numbers? Like whether it's one person or two people, whether it's that are being admonished or censured, whether it's 5 people or 6 people that are voting, you still need 4. Mathematically, you still need 4 to get it done. So I don't think that there are a lot of permutations that need to be thought out, but we do need to explicitly put them down because, again, any tool that you make can be used for good and for bad. A sword that can defend you can also hurt you. So these are the reasons we need to be very careful with these types of things. And before we simply, again, ascribe any kind of authority or jurisdiction to even this civil grand jury, we should really stop and think what's the right thing to do. And if it agrees with their recommendations, that's fine. But to say that the recommendations are the sole things driving some of these, I find that sadly laughable. And again, you can ask me what experience do I have? We've had 2 civil grand jury reports. More than that, actually. We've had 3, but 2 that specifically talk about these council members. And when you look at the actual findings, the findings are not supportable other than they've been written in the final report. So, and again, this is why now especially, I want everybody that's elected to be part of this, because saying that, not thinking about the clerk and not thinking about police chief and not thinking about other elected officials has actually left a lot of holes, a lot of openings. And, I think that if we're going to make these, then let's just think a little bit wider and get the people who unfortunately have been missed throughout these processes.
Councilmember Park, I appreciate the comments and the feedback. I do want to clarify, I may have overstated, what I said about the grand jury findings. I want to make clear, I reviewed the grand jury reports as part of my process to update these policies, but I did not take nothing in this policy was a recommendation from the grand jury. I just want to make sure that that's understood. But your points are well taken, sir, and I will come up with alternatives for consideration.
Okay. So do we have a recommendation for whether we're going to use may or shall? Is that something that we want to vote on?
Keeping in view the comments from city attorney, I would suggest we should use may. Shall we always have to do it, basically, irrespective of what the content or how good report you're getting from somebody is.
Member Park, did you have something to say about that?
I did. And in general, I think for safety's sake, I actually prefer may instead of shall, because I see those as can and must. The may and shall is can and must. I mean, in engineering documents, you often see that, well, may means this, shall means this, must, these things. At the same time, what's been very frustrating in my tenure here is there are things that we should 100% refer, we should 100% bring up. And instead, we say, well, we're going to do an internal investigation. I've yet to see any feedback, any actual reports from internal investigations. I have yet to see how the may has benefited the city when it comes to real problems. I feel like there has to be a way, there needs to be findings, as Committee Chair Jane suggested, on this is a finding that is big enough that we shall do this. I think that there, if we can make those findings. But my frustration from my years on council have been, there are big things that should warrant an investigation outside, that should warrant more than just, well, we think it's a problem too, but unless somebody wants to sue, nothing's going to happen. There should be, things that at some point do get referred for investigation. I mean, I have a lot of people that I know that work in DA offices and they tell me that the DA's office is not really an investigative office. They said you should not really look at the DA's office as investigation. They can do investigation. They can look at civil grand juries, can refer to criminal grand juries, and they can do investigations through that. But the reality is most DAs are prosecutorial. They don't want to see investigations happening in their offices. They want to see the evidence that's presented to them, and based on the evidence, they want to be able to prosecute or not prosecute. This is a very big thing that we need to consider when we come up with these policies. All right. But again, I think that there should be something that says we need to refer this. I don't want to see, well, it's up to you. If somebody wants to sue, if somebody wants to do that, it shouldn't be up for that. The other concern I have is it says anybody can bring up these admonition and censorship. It could be the public. I voted against it, but this committee, the governance committee, actually removed the public's ability to agendize items because we said, well, what if they agendize, as has happened, bad things that we don't want to have to consider? Well, I think that's unfortunate in democracy. You have to consider bad things and you just say no to them if they come up. But it's just funny to me that we have given the public more power to admonish and censure than we have to simply put an item on the agenda with the policies as written and with the changes to the O30 processes, the process that we did, earlier. So, I mean, I want to think about all these different things because the call for censorship, the call for admonition doesn't usually start from council. It usually starts from the public. So we need to be very clear where this happens, and we need to have the guidelines for how it happens at stone. Thank you.
Okay, so in terms of the members of the public, I think we modified the 030 process such that you need a sponsor. Just need one other council member to help with that because we had members of the public just willy-nilly doing 030s on censorships. In terms of the may shall, my opinion is that it all depends on the level of substantiation of the allegation. If somebody were late in filing an FPPC form, I don't think we should be required. I don't think shall makes sense for that. For other things that are FPPC violations, like, conflicting donations, in that case, I think it's still up to the council to decide if they're going to refer it to the FPPC. In terms of criminal conduct, again, it's the level of substantiation. If you heard a rumor that somebody did something, is that enough to bring it to the council to refer the matter? Or, because then we're going to get a lot of rumors that we have to follow up on. It all depends on the level of substantiation. So my preference is to go with may for both of these.
And that's the reason, like may is forward compatible. We can take a decision with shall would have taken basically, but shall is not backward compatible we don't have any if we take shall, we eliminate may part of it, whether some documents are not. That's why I was also going for may on that.
But again, I see the policies that we're talking about, what we're talking about here is two different things, which is there's the admonition and censorship policy, censure policy, not censorship, but censure policy, which talks about this process. And then for criminal and FPPC violations, the question is, if there is a criminal FPPC violation, should we then refer? Right? It's not about the shall and may and shall do not refer to, I believe, the admonition and censure part of this. I think that they're specifically with regards to criminal and other investigations.
And Chair, if I might, just to follow on that, I think you're exactly right. I think there's two parts of that. What I'm hearing is consensus on may. We may build the language a little bit to give a sense of when it might be appropriate to, depending upon availability of evidence or, or severity of the violation, to kind of flesh out a little bit some of the issues you're saying. But the other point, and we talked about adding a paragraph, all of this I think is going to come back, to you. So we're just kind of in the flow here, but to add a paragraph that makes it a little clear that if, what actions would be appropriate if in fact there's a criminal prosecution or an FPPC, violation pending. And so we got a lot of feedback and information about that. And I know notes are being taken. And so when this comes back based on consensus of May with some enhanced language there, and based on a desire to have some clarity about what, if anything, you do while matters in front of the criminal or FPPC matters are pending, all of that can and will come back in a future version of this. And again, outside counsel nodding, so I think I captured that correctly.
Okay, so, and the reason I'm speaking is because I didn't actually hear a consensus on may versus shall. What I heard was, I heard two people say, I would like may for this, and for this reason. But what I heard is may or shall depends on the level of substantiation. Like rumors shouldn't be enough. And what I brought up is exactly this, which is there should be some level where shall is in fact the working word. And the thing that we talked about earlier, which again seems to be dropped, is when you're working in a judicial or quasi-judicial mode, then you need findings. And I think at some point, I would like to see some findings that if those are met, they change the may to a shall. Like, I would like to see that. It doesn't mean that you conclude the investigation and find guilt. It means we think that there is enough here that is important, that is relevant to the city, to the management of the city, that a referral to another board, a higher jurisdiction, is warranted. And so again, I hear the words may, but I don't believe that the thought consensus was actually the word may. I think that the thought consensus was, if there are ways to determine a shall, then perhaps a shall should be considered.
Member Chahal.
So when the facts are presented, Member Park, the may can be converted into shall. Like when the council decides we have to forward this thing for investigation to district attorney or whatever the next process is, may will convert into shall once we have the data, basically investigation. So we are not eliminating the shall part of it. We are only saying, depending on decision, may can convert into shall. Like when the whole council decide, let's refer it to so-and-so, that's sort of a shall statement. No, we are not eliminating that. I just want to clarify that. We're not eliminating that part of it.
Okay, and I just want there to be findings. I want the way to convert a may to a shall to be explicit.
Okay, yeah, that's fine.
It seems to me that any member of the council could do a 030 and then have a formal hearing to decide whether to refer something to a higher authority. Oh, okay. City manager.
Yeah. I know we have to bring this item back. And so as the city attorney said, I think we can provide you with some draft language to accomplish the goals that have been articulated. I think Committee Member Park totally understand the point you're making. Should certain findings be made, a referral shall occur. And I think we can nuance that and bring you back something to churn on a little further. Also, as I just want to remind us why we're here and highlight one thing. So as we go into the procedures for censure, I think it's important to note that the recommendations that you're being provided by Maureen for the Ad Hoc Ethics Commission is intended to be an ad hoc committee of the council. Now that is distinctly different from, again, phase 2 that we will be looking into, or that our consultant will be looking into about an independent ethics commission. So the committee may find that this process is something they want to really consider in light of the phase 2 work, because what this would be converting your current process. And I would actually recommend that we may not call it an ad hoc ethics commission, and maybe in here just call it an ad hoc committee, because it's a committee to look into the allegations. And so just know that you can pause on the censure part of it and really consider that when we bring you later on this year, the information on phase 2, which is an independent ethics commission. Because in the long run, either you're going to have council procedures or an independent ethics commission procedures. And so you don't have to take this action or provide specific direction on the censure component today. We wanted to bring that to you because Maureen had concluded her work and her recommendations on phase 1, and we just didn't want to be holding that information until phase 2 was done. So know that that's an option.
Okay, Member Park.
So again, I want to talk about a couple of things. The first thing is I mentioned about the public, and I think rather than leave that up to chance, I should state it exactly. Tell people what you want, not lead them to where you want to go. But we have a policy for bringing items to the council to agendas, which is the 030 policy. And I would think that the censorship would be, or censure would be, no, it is censorship. It's different from what most people think about censorship, but censure would be very similar. It would be brought forward. And if that's the case, and if we believe that the reason that we changed the 030 policy was to prevent spurious items being put on the agenda from the public, then perhaps that should be one of the methods, which is the public doesn't just come and say, I'd like to do this. Maybe it is an 030. It requires sponsorship. It needs some review from staff. Right. Again, I don't want to put, bless you, I don't want to put more work, but I think it's very important that we keep things consistent, right? Because I know it's like Jevons Law. You make a process, you make a resource more available, and that resource gets used more often. So I'm concerned about that.
If I could Mr. Chair, just to address that, I don't think anything about what's proposed in front of you would give the public any independent right to agendize something above and beyond what the current standard is for how something gets added to the agenda. So, Member Park, I just wanted, before you went on, I think that addresses that. It would still be, no one from the public would be able to require you any more than they could require you to add any other item on the agenda under current policies to agendize either admonition or censure.
Okay, and I understand that, and I see that there's the Ad Hoc Ethics Commission, which I think that we've talked about 2 different types. There's the Council Ad Hoc Ethics Commission, which I think is, again, putting the cart before the horse when it comes to you're having the council members, some subset of council members, I'm assuming 2 or 3, because it can't be 4, decide in advance whether or not we think that, they think that this is important to bring. And I'm going to state again, I think it should be, especially when it comes to ethics, especially when it comes to conduct, I think it should be investigated by people who have no vote in this, whether it's council members looking at censure admonition of another council member, whether it's an independent ad hoc committee looking into, investigations of council members or other people as well. I think that the investigative and the ad hoc committees need to be people without skin in the game, because we have seen time and time again that people with skin in the game can move the needle appreciably. It's not something that I want to see. And again, even though it doesn't preclude the process as the city attorney has suggested, it certainly doesn't prescribe that process. And that's my concern. My concern is if there's a way to misunderstand the process, if there's a way for people to complain, well, this is the way I think it should be done, then that's what I think will happen.
Do we want to take a vote on this or just have, after you describe the mechanism for findings, we'll come back and vote on?
Yeah, right
Yeah.
now, we're just taking feedback.
Yeah.
Okay,
And we'll
great.
come back.
Yes, my hope is, yeah, to get all of your feedback today, and then I'll be back in a future meeting with additional updates for you to consider.
Okay, there's one more restriction of activities. Is that what we're gonna do?
Yes, if we're ready to move on, we can just get the PowerPoint back up. Okay. Oh. My clicker has suddenly stopped working. Maria, are you able to advance the slides? Thank you. Yeah, always have a backup plan. Keep going. Keep going. Here we go. And then the next slide, please. Okay. So I also, as part of my work, took a look at your ordinance, chapter 2.145, restrictions on activities of city officials and certain city employees. I didn't find a whole lot that needed to be updated in this instance. I did add the vice mayor to the definition of a city official within the policy, within the ordinance, but did not have any other changes there. So if there are any questions about that, happy to answer them. Or if you have any comment or feedback about that.
I didn't, it's, Member Park, did you have a comment?
I mean, I see that you added vice mayor to definition of city official, and I think it's understood that the vice mayor is simply something that's, added to the council member. There's no different. However, because, and I don't think that vice mayor is actually explicitly called out in the charter, other than the vice mayor, it's understood will take over for the mayor. And the mayor does have a few things that are different from the city council. But I'd like you to keep that in mind, that, like, I don't know that adding vice mayor will add clarity. I think it will actually bifurcate. I think that it should be understood that vice mayor is, in the definition of a city official. But I think the key point is that it's true that the mayor and council should be treated equally. But because of the additional responsibilities that the city mayor has, I would like to see additional guide rails or what the mayor can do. Meaning there are many things that our mayor is allowed to do in addition to council. And I think that those allowances should come with guidelines. If they don't have guide rails, if we say that we're going to treat everyone the same, but the person with a stick, we don't have rules for sticks because, well, only one person gets to carry a stick. That doesn't seem right. I think that if we're going to treat the mayor differently, then we also need to consider the mayor differently.
Do you have any examples?
I mean, the mayor can speak for the city. The mayor is often the first person that people go to for news, for other things, not for the Super Bowl, but for news and other things. But it is, we had an incident where, we had to discuss letterheads. We had to discuss how, letters get sent because we had, during an election year, somebody sending unofficial letterhead comments on behalf of the rest of council. And I think that is something that should not be explained away with, well, they can do it. I think that even those letters and the information that was sent should be considered under code of conduct. This is when you should not do it. This is why you should think about this. This is why you must think about this. This is why you must. There must be additional guide rails if we're going to give additional consideration.
Member Chahal.
I agree, actually, I agree with that. Like, there have been instances when during the election year, it was weaponized, like from the office of the mayor, something was sent on the flyers. So I think that we need to check that. It should not only apply to the mayor, it should apply to us as a council member too. I, as a council member, should not be sending election material from the office of council member as such. So same restriction should be applied to the mayor too, basically. We need to look into that. And we did find that issue in the elections, basically. So that need to be issued. My other suggestion to Maureen is, can we get the red line version of these changes we are making on all the policy? Because it was very difficult for us to go back and forth and find out what actually has changed. So if we can get a red line version before the next meeting,
Yes.
that would be really good for us to
Absolutely.
make sure. Yeah, other than that, I'm okay with it.
I didn't have any comments. Any member of the public? Oh, city
I'm sorry,
attorney.
I stepped out and got a little confused of what we were talking about. And I think, did you just present on this, okay, so.
I think
understand now,
that
Sorry.
the idea was that these are restrictions. The only thing that was changed was adding the vice mayor.
Yep, and adding vice mayor, yeah.
And then
Very
did you
good.
hear,
I just got a little
did you
confused.
hear
about
member Parks?
Subsequent discussion. So now I understand. I'm back with you. Apologize, Chair.
It's because it seemed like we needed to define vice mayor that I said, well, we need to think about what it means to have a differently elected, has different powers, mayor as well. That was my basic.
Yeah, very good. And just to be clear, this policy only relates to the conduct of city officials, after they leave, office, right? So it's their restrictions of conduct there. Okay, very good.
Chair Jane, there's no one with their hands raised online.
Okay.
I'm
Member Chahal, did you have, city
I'm
manager?
sorry. I just want to have clarification because I want to be able to appropriately direct staff and the consultant. As the city attorney said, this section relates to restrictions on activities for city officials post-service. What we heard is a desire to adjust the duties of the mayor through this review of ethics documents. And so I have some clarification that's needed on what's actually being requested, but I've in changing of the duties, but I want to understand if that is actually a direction that the committee wants to provide, only because I heard two of the three committee members suggest that some change or clarification in the mayoral duties should be done.
Member Chahal, did you have a question?
Yeah, I just want to clarify the point I was talking about. Whether it comes under the ethics part of it or whether it comes in the restrictions on what the restrictions on the activities of the council member and the mayor. I think we need to define that. Like when somebody is representing in official capacity, I think that should be in a different way than making a election campaign process, basically, because we have seen that in the past. Office of the mayor has been represented, like election material has been sent showing is from the office of the mayor. I think we need to control that. Wherever we want to in this whole process, wherever we want. And I'm not saying office of the mayor, office of the council also, like I should not be doing that when I'm sending those letters in the election campaign material. It should not be. I can only use my name as Raj Chahal and council member only as a recognition that, okay, this is for recognition only that I'm council member over here. So that type of restrictions should be put in some of, whether wherever we want to put it on our ethics code or processes, we should be putting that additional restriction.
City Attorney.
Chair, thank you. Appreciate those thoughts and comments. I think there's other discussions that are ahead of you on behavioral standards and the ethical policies and how that might apply in those circumstances. So I think that kind of discussion is ahead of you. I just didn't quite understand it as it related to what I thought the ordinance was that was in front of you, but certainly in context potentially as we get deeper into behavioral standards, with the idea being that there might be behavioral standards that both universally applicable to all council members, but maybe even some elevated standards for mayoral conduct. So it helps me to put it in context and maybe our outside counsel too, as we dive into the next.
Yes.
Understood, and I apologize. I think that I created a little bit of the confusion, but again, my point was, if we're going to have consideration based on titles, if we're going to have consideration on things like that, then we should make sure that we have consideration based on actual differences in our roles.
Okay. All right. I think we're probably not even going to be able to get through this by 12:30. So we'll try, but we'll have to defer the other item to the next meeting.
You want to defer the behavioral standards portion or?
I think we can go till 12:30. Is that
Yes.
correct?
Yes,
We
I
might
think
as
we can
well.
get through this item. I think it's the other items on the agenda that we would need to schedule a subsequent meeting for.
Okay.
Yes, so, oh,
Yeah,
my apologies.
Proceed.
Chair.
Yeah.
Okay, thank you. So with respect to the behavioral standards for council members, I wanted to wait until we finalize the other policies that we have talked about before I go in and update the behavioral standards, because the behavioral standards are very much tied to the City Code of Ethics and Values for council members. So we've received a lot of great feedback today, so I will be coming back with updates to that and then recommendations for the behavioral standard as well, fully in track changes for everyone. The other component that I wanted to cover with you today are some recommendations for ethics training for the city council. You know, the part of the purpose in doing these updates is to, you know, clearly communicate to all elected officials on the council what the expectations are when it comes to ethical behavior. And then there are also, and that relates to the city policies on that, but there are also ethical requirements required by state law that you are required to be trained on. And so my recommendation would be that your current training that's being done simply be updated to include the changes to the policies that will be forthcoming. Obviously, it's still a work in progress at this stage, while also continuing to cover the required elements of the training under state law, specifically under AB 1234. Since there will be some comprehensive changes to city policies on ethics, part of the recommendation for the city council's consideration is perhaps we do some sort of yearly refresher, yearly training on ethics. The law requires every 2 years, but for your consideration, you know, perhaps we consider annual training, at least for a period of time, given that there will be changes to the internal policies on ethics. We will also continue to ensure that we cover the components that are required by state law, which are, you know, regulations under the Political Reform Act, conflict of interest issues, Brown Act, Public Records Act issues, and then some real world applications, meaning some interactive exercises are also recommended as part of the training. So that will include real life scenarios based on examples of conflict of interest issues that come up, misuse of resources, dilemmas around transparency. We can also set up scenarios or simulations that involve decision-making issues such as how to handle confidential information, interactions with lobbyists or groups trying to influence council members, and what we can do to avoid the appearance of favoritism. I've mentioned that we will integrate the updates to the city's policies into the training to make sure that everyone understands what the new requirements are. We will also, as part of that, again, this will be in the city's policies, highlight the ethical principles of all council members. And then also put an emphasis on culture building among the council so that there can be open and free-flowing discussion that's also productive for the city council. In terms of who can provide the training, you can, engage your outside attorney consultants to come in and do the training. LCW, for example, handles the AB 1234 training for organizations throughout the state. You may decide to have your city attorney's office handle the training, which I believe has been the case. Glenn, is that?
Since I've been here, it's been the case, and
Yeah.
I shared with you my presentation.
Yes,
And there's another one coming up on March 17th.
very good, very good.
And just as a note, and I can talk more about it later when you're done. My version of the training incorporates not only the required AB 1234 aspects, but some level of what our local ethics code provisions are. And our thought was this time to even go a little bit deeper into that. Not so deep because of pending, with the changes, but
Right,
I think that's always an appropriate part of that training, both AB 1234 core principles and of course our local rules that reinforce.
great. And then from time to time, you may want to consider, having guest speakers like from the FPPC to be involved in the training if that is helpful. In terms of the resource materials, you've got your city policies. You have your city attorney's office preparing the materials so that we know they are legally compliant with AB 1234. There should be documentation maintained that shows that all elected officials are getting the training at least every 2 years, which is what the requirement is.
And just to note on behalf of City Clerk's office, that is going on. And the training that I do, so long as people actually physically appear, also issues a certificate for folks who need to be in compliance.
Right. And then, the last point, what I would suggest happen is that once the policies, the changes to the policies have been finalized, we can coordinate with the city attorney's office, take a look at the training materials, and, make any recommendations for updates there. And that's it for me for today.
Okay, you have any questions? Okay, Member Park, okay. So we have these code of ethics pillars. And if you look at the behavioral standards, there's different pillars there now. One is ethical, collaborative.
Yes.
So what I really like about this is that you have these role model behaviors, an example of behaviors, actions to avoid. Are you going to follow the same process when you come up with the behavioral standards?
Yes. Yes, I like that process too. I like the examples and I'll be taking a look at them and see if, we can update them with some new or different scenarios
And when will we see that?
at the next meeting.
Okay, and then,
Sorry. Chair, we may need to schedule a special meeting just
Yes.
because our work plan keeps getting pushed out. So we'll probably schedule a special meeting.
okay, and then the phase 2 part of it, the Ethics Commission, when will we see that?
We're in the process of finalizing the contract right now, so it will probably be summer, fall, I'm assuming, to this committee.
Okay, and then, of course, we have our city clerk here. Are we allowed to discuss the ethics around elections? Or is that the purview of the city clerk? Wanted to understand in terms of the last word forums and the trainings that we get from FPPC and League of Women Voters and such.
When you say allowed to discuss.
Well, I think that
what do you
was,
mean By that.
when we carved it out, that was given to the city clerk to handle all the elections related issues.
Yeah, I think the way that was done, and I'll certainly defer to the city clerk if he or his staff thinks differently, is that city clerk is the elections official. And this is something we may talk about when we get to the consideration or review of the charter. What it means to be the elections official, can vary from city clerk, to city clerk. I think it would be and could be an appropriate discussion in consultations with the city clerk as to what elements of campaign ethics the city council might support either through policy or otherwise. So I don't think it's precluded by the fact that you have an elected city clerk who's the elections official, but there certainly should be appropriate kind of deference and collaboration with the city clerk in that function. That's my thought.
Yeah. City clerk?
Yeah, thank you, City Attorney and Councilmember Jane. I really don't see a difference in ethics between campaign ordinances and campaign reporting of FPPC issues compared to other issues that the FPPC has. As everyone knows, I'm new in this position, so I'm going to be working closely with Nora on this. But it's no secret, all the reporting that candidates and council persons, including the mayor, have to do is public record. So I'd be happy, as you notice, I've been attending council meetings and I will continue to attend all of them, especially if there's an elections official or something that the city clerk's office handles. I will be here for all those. So as far as ethics go, it's ethical to be a candidate. It's ethical to be a council member. It's ethical to be any employee in the city. So I don't see a big distinguish between the two, and I'm happy to work with everybody, city manager's office, city attorney, and the council and mayor to get those done. And I think that's what we're going to be talking a little about later. Why City Attorney Guggens asked me to attend this meeting is some roles of the city clerk along with other issues of the charter.
Okay, very good. The last thing I had was that at the last AB 1234 presentation that city attorney did, it was really good. The scenarios were great, but I didn't think we covered enough of the city's code of ethics and behavioral standards for the public. And since we have to do these every 2 years for the AB 1234, could we then, on alternate cycles, cover the city's code of ethics and behavioral standards more in depth and maybe not make it an official 1234 training? And the reason is that I don't think the public really understands that we have this code of ethics that we have to follow. And now we're going to be signing an official, attestation. But I just think that the public in general doesn't know that we have these already.
I appreciate that comment. And I do think as good and as complete as I think my AB 1234 training is, and how in some respects it's unique in that it does talk about our local rules, I can't possibly in a tolerable time period, some would say I'm already testing that with my 3+ hour presentation, do our local rules justice. And so while my presentation back in October 2023 and my upcoming presentation will certainly talk about our local rules, in order for me to get through everything I need to get through and make sure people who need to get certified are certified, I won't do it justice. And so I certainly would support that if the council wants, as part of a training regimen to encourage as a supplement to that, or however the training, policy comes out. And with whatever frequency makes sense, yearly, however that would work, supported by our office with outside counsel, deeper dive into what our local rules are and how they work and how we administer those. So I'm certainly supportive of that, as your city attorney and city manager, I think, wants to comment as well.
I just would piggyback and concur and suggest that we do it on a biannual cycle during council onboarding, right? So if our city attorney is doing the AB 1234 on the odd years, we can do them the next year and align it with our council onboarding.
Member Park.
Yeah, so, and I like Chair Jane's suggestion of having something focused on city. I mean, we have a lot of noise during the elections, during campaign seasons with lots of different ethics codes and people referring to them and people not being allowed to sign them, not even knowing about things. And I think that the people need to understand that, you don't want people to sign ethics papers willy-nilly. I mean, I always say in science, that scientist will sign anything. They will tell you that, oh, I have all these certifications, they'll do anything. And it's the people who are trying to make sure that the science is correct that are very careful about what they sign. And I think we need to get the understanding that ethics is very, very similar, which is people who are not ethical, they'll sign anything to show you that they are. This is a problem. I would like the AB 1234. I just attended training in Sacramento. And I look at what they do. I also attended the training that our city attorney gave. And I kind of feel that the length, absolutely correct. There is not enough time in an hour, 2 hours, even 10 hours to tell everyone about all of the things that could possibly come up. I would like events for the purpose of certification to focus on certification requirements. And on off cycles, I would love to have, some knowledge about what the city's code of ethics is, and that there is a code of ethics and people have to sign it. I do have some issues with, like, the city clerk. The city attorney mentioned that the city clerk, how people look at the role can change from person to person. And I don't think that should be the case for some things. We have not had, as far as I can remember, in the last, three elections, which is a long time. That's the better parts, more than half a decade. First and last word forums, maybe in the last decade. I don't know if I've seen them. And this used to be something that the city sponsored. And when we take a look, there is no record of this. And I think that something should not be a matter of who is in the position. Something should be a matter of this is what the city provides. This is what the city does. And if the city has no skin in the game for its elections, then the fact that we have an elections officer means absolutely nothing to me. I also know that in an election, we have an ethics pledge that everyone can sign. But it turns out that incumbents, people who are already elected, are held to a higher standard because not only can they sign this ethics pledge, they've already signed, as the staff has noted, they've already signed the pledges that are required for assuming office. That is not true for candidates. That is not true for candidates that have not assumed office. I think that's a very, very big hole. And the ethics pledge is not a you must sign this. It's a voluntary statement. And by letting people say, well, I signed a different ethics pledge, that is a terrible thing. I think whoever, came up with this idea didn't really think about ethics. Ethics wasn't really the point of having these alternative things. It was really about going around, having other things in there. Again, if we're going to have an AB 1, 2, 3, 4 focused course, then I think it should be focused on what's required for the certifications. And if we have an ethics pledge, it should focus on ethics, right? Shouldn't have other things in there like, well, you must agree with a civil grand jury that was, brought up. It shouldn't have things like that. And for that to even come up in election, I think is noise that we don't need. This is something that we should prescribe in our city, that this is what's required. If people want to do other things, that's fine. But let me tell you what that means. Right? I think we need to have those things written down. I think that it's important that we have something like a first word and last word forum. The first word was supposed to be introductions. These were introductions, not political. Not really, this was sponsored by the city. It happened right here in city council chambers. We had the last word forums. The last word forums were to talk about, well, questions that came up, ethical questions, accusations that came up. They were moderated by, consultants, ethics consultants. Last year, I talked to a number of people who had moderated forums in the past, and they told me, well, we reached out to the city of Santa Clara, and Santa Clara said nothing. They basically said, no, thank you. We don't need to do that. And I think that rather than here, no, thank you, we don't need to do that. I think it should be, these are the things we do. And, and these are the, if anyone can help, if the people that moderate forums can help, we would like to do that. But to leave this up to the, vicissitudes of whoever's in the office doesn't make a lot of sense to me. It doesn't really do the city, doesn't do the constituents any justice. Again, we need to take into account that candidates don't have to sign. Like if an elected official runs for re-election, they don't have to sign an ethics pledge. They already have to be ethical. They can lose their office. Well, I mean, it's supposed to be, but they've already signed something. But for an ethics pledge or a behavioral standard to be optional during an election cycle for the city seems like it's a miss. I'm not saying that we should enforce this, but I want to think about that, right? Because right now, it's not just not enforced, it's optional. Last thing to consider, and this is why we need to think about this, is, I mean, we talk about guidelines, we talk about rules, but guidelines without any effects, just a piece of paper on the wall. They say that a leader without any followers is just a person taking a walk. And I think that in the past, what I've heard is, well, this is our ethics program, our ethics code in the city of Santa Clara boils down to this. If you don't think somebody's being ethical, don't vote for them. And I think we didn't need to spend tens of thousands of dollars each year for an ethics consultant to tell us that, right? And it seems that in the last 10 years, it's true, we haven't needed somebody to tell us that if someone's not being ethical, don't vote for them. But I think there should be some effects for people who are not being ethical. I think there should be some discussion of these are bad things that have happened in elections. These are the things that have come up. One of the reasons that we had an ethics consultant not hired again was they completely ignored the ethics issues that came up during the election. Some ethics issues were big enough that they had police complaints associated with them. And when you have situations like that and you dismiss them as, well, there was nothing to discuss here. I mean, quite frankly, residents, they lose faith in the process. And this is when they start to think there are no ethics in the city. And if we want to restore that, we have to restore that in lots of ways. And it's not just council member behavior, it's everything. It's the elections official, how the elections are being run. It's the opportunities that the city has to show that this is what we're doing to ensure that our elections are good. The erosion that we've had in the last decade, I think that's the issue. It's not the fact that people are ethical or not ethical. It's that we don't care if people are being ethical or not ethical. And if we do care, nothing in our guidelines, nothing in the effects that we have, in the consequences that we show, in the options that we have for restorative or corrective action, nothing shows that. So this is what I'd like to see.
Yeah, just a quick comment. Are we referring this email we got from Srinivasan Manivannan to city attorney and consultant to look at? I don't think it relates to the Maureen, but city attorney, can you look into that? The letter we got, which is attached to our agenda today.
Well, I can speak to that at our next meeting. I think there actually are already rules in place that address that, but I can speak to it at the next meeting as a report. If the consensus of the committee is supportive of that.
Please.
Okay. Do we need to take any action on item number 2? Or just bring it back?
No, I think we've got input that is being digested, has been digested, will be digested with the report back. Turn it back over to the city manager. Maybe the next thing that we might need to do is talk about if we're going to defer all the rest of the agenda items, when we might connect again and start taking them up. I do have some interest in timing on the item number 3 regarding the comprehensive charter update, given the timing and desire to potentially get on the 2026 agenda. It's not like it needs to be tomorrow, but maybe before, the June meeting. And I know there's an interest in coming back sooner rather than later with the work that you did on the ethics report and review.
Okay. We have a hard stop at 12:30. Do you have a recommendation then to put the charter discussion on the next meeting and then defer the other ones as needed?
Well, Chair Jane, what I think we need to do is schedule a special Governance and Ethics Committee meeting to address the balance of this agenda. I think, as the city attorney mentioned, most important is getting through item 3, because if the committee and then the council does want to proceed down this path, time is of the essence. Item 4 was discussing a potential policy around the start time of city council meetings. I think that is an important discussion that we need to have sooner rather than later. And then the work plan, I think we certainly need to discuss that, as well as we know phase 2 of this will be coming back this year. And so we'll appropriately adjust that. So with that said, I think our goal will be from staff to go back after this meeting and work with staff that schedules these meetings and try and get one on the calendar as soon as possible. These 3 items are ready to go. We just need time.
Okay. Motion to defer the 3 balance items to a special meeting.
So moved.
All right, all in favor?
Aye.
Aye. Opposed? Okay. Is there a staff report or anything? Committee reports? Any future referrals? All right, and we are adjourned.
Thank you.